Smith.
Let's go ahead and proceed.
Your Honor, we're here on what was previously filed as a agreed motion to attach witness, a third-party witness who was the passenger in the defendant vehicle, was subpoenaed to oral deposition and failed to appear. And since then, we had a hearing with the court, and we're told to file a motion to show cause, which is what we're here on this morning.
Okay.
And we personally served the defendant with notice of this hearing, and filed that return of service with the court. I'm not even sure if that was a requirement, but just to make sure that he was looped in. And I have not received, there was also a letter inviting him to contact us to schedule a mutually agreeable time to be deposed, and we haven't received any communication from him. So,
Mr. Hatcher, any opposition?
No, this is an agreed request, Your Honor. Mr. Rice, who is the witness at issue, is a key material witness in what is a liability dispute. So we all really need to depose Mr. Rice.
Okay. I don't see that you submitted an order on the show cause. Did you submit that? I don't see it on the system.
I don't believe that I did. No, Your Honor. I can get that submitted today.
All right. Make sure that it says at the beginning, instead of on this day, that this was heard on March 28, 2022. And then make sure you share well, actually, we need to set a show cause hearing. So, let's set this on, let me just look at my dates. Let's see. Long year. Okay. Let's set it on April 22nd at 9 o'clock. And then if he doesn't show up to that, we'll go ahead and attach him.
Okay.
All right, guys. Thank you so much.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Okay, I think we have a hearing on a motion to strike. Is that correct?
Yes, Your Honor.
Good morning, Your Honor.
Okay. Let's go on the record on cause number DC 204909, Cade Bay versus Fenici. Counsel, make your appearances.
Your Honor, my name is Matthew Parr, attorney for plaintiff Naomi Cadebay. Today, Cade Beyer, attorney at our firm, will be arguing the motion.
Okay.
Good morning, Your Honor. My name is Kyle Markwart, and I'm counsel for Monique Fenici, and my partner, Andrew Norman, is here as well.
Morning, Your Honor. John Andrew Norman for defendant Fenici. We'll let my associate Kyle Markwart take lead on this hearing.
Okay. Let's proceed.
Good morning, Your Honor. My name is Cade Beyer here for the plaintiff. We have two motions set for today. One is to strike the counter affidavit of Dr. Don West, MD. The second is to strike the counter affidavit of Dr. Roger Clifford, DC. So a medical doctor and a chiropractor. I'll start by arguing to strike the counter affidavit of Dr. Don West. 18001 sets out two clear standards that they have to meet. One is that the counter affiant is qualified in order to offer his opinions, and second, that he offers a reasonable basis for those opinions. Now, starting with the reasonable and necessary treatment, which Dr. West refutes, he makes blanket assertions that had plaintiff taken non-steroidal anti-inflammatory drugs, that no treatment was necessary, and that the literature supports that the treatment was over the top and superfluous. But he's never providing any citations, he's never explaining any process, and he's not providing any sort of basis that plaintiff can look to see whether his assertions are correct. Now, certainly, In re Allstate opened the door in regards to these motions to strike by allowing people to testify to things outside of their area of medical expertise. But even in that case, the counter affiant, she very clearly articulated her process. She was examining CPT codes on bills, using the online database Context for Health. I mean, if plaintiff wanted to double check her work, they can go to these databases and see where she's getting these assertions. They can see her basis. Here, Dr. West never lays out these bases. Second, in regards to the reasonableness of the charges, he states that Well, I refer MRIs out to other facilities, and therefore I'm familiar with their charges. Well, he's not a certified professional medical auditor like the counteraffiant was in Ray Allstate. And second, he's not even naming what facilities they were referred to. Again, we don't know what those charges are. We're not able to compare and determine whether these charges were reasonable or not. And so for this reason, he's making a series of blanket assertions that we can't look to ourselves to determine if there was a reasonable basis.
Okay.
Second, well, I'll defer to you, Judge, whether I should move towards the second motion to strike or.
Go ahead and do both at once.
Okay, absolutely. Starting with the second motion, Roger Clifford, DC, he claims that none of the treatment was reasonable or necessary, and that therefore all of the billing was unreasonable. This is again going towards he's not offering a reasonable basis. His position on this issue is interesting. He's saying that it was inappropriate and below the standard of care to render treatment following an accident without properly documenting the medical history. Now, he does provide citations, but again, his focus is that the chiropractor facility in question that he's challenging didn't document plaintiff's medical history well enough, and therefore the treatment and the billing was unnecessary and unreasonable. And I understand that he is providing a basis, but it doesn't connect towards the treatment or the charges. When we're talking about documentation of the medical facility, at that first visit, there would have been no documentation. So at the very least, certainly, he can't say that her first visit was unnecessary or that the charges were unreasonable because they didn't document it beforehand. And even as she goes through the process, whatever complaints he has with his chiropractic facility as far as their ability to document the accident and to explain these sort of things, that doesn't go towards her injuries. It doesn't go towards whether or not she needed treatment. And it certainly doesn't address whether or not these charges were unreasonable, which again, he takes the easy argument by saying absolutely all of it carte blanche was unnecessary. Therefore, all of the billing was unreasonable. And that's, again, it's not laying out a basis that's connected towards the treatment or the charges.
Response?
Thank you, Your Honor. Kyle Marquardt on behalf of the defendant. Essentially, plaintiff's arguments in their motion can be broken down into three distinct topics. They argue that both Dr. Don West and Dr. Roger Clifford are unqualified, that their opinions lack sufficient basis, and that their opinions are unreliable. All three of these issues can be taken care of by looking at the text of the statute, as well as the recent Texas Supreme Court case in Allstate. Under the text of the statute, Section 18.001F of the Texas Civil Practice of Remedies Code distills two substantive requirements for counter affidavits. First, they must give reasonable notice, and second, that person must be qualified to testify. Both of those standards are met in both of these affidavits. The Texas Supreme Court in Henry Allstate has found that initially there is no reliability requirement under this text. There's nothing in the text of 18.001F that requires that an opinion expressed in a counter affidavit meet the admissibility requirements of an expert testimony. And whether a witness is qualified to provide expert testimony and whether that expert's testimony is reliable are completely distinct inquiries. So right off the bat, the unreliability issue is resolved by that case. On its face, both Dr. Don West and Roger Clifford are highly qualified in this to give testimony on this subject. Dr. Don West, has been licensed to practice medicine for over 30 years. He's practiced in the Dallas market since 1986. He's been a medical director for 3 facilities, and he's treated thousands of patients with similar injuries to that of the plaintiff. Similarly, Dr. Roger Clifford has 27 years practicing as a licensed chiropractor in this area. He's board certified as a chiropractic neurologist, and he's treated, again, thousands of patients for similar injuries. Finally, they've given reasonable notice because in each of their counter affidavits, they've highlighted exactly what part of the medical bills they disagree with. They've highlighted for plaintiff the areas that they find questionable or that they find were unreasonable and or unnecessary. Because of that, and because of the standard for counter affidavits that does not need to meet the level of expert testimony, we ask that you deny their motion to strike on both.
Response?
Just very briefly, Judge, I'll say that we have reviewed their motions or their counter affidavits. I understand their qualifications. I understand their experiences, and I understand their opinions as far as how they disagree with the bills and the medical treatment that plaintiff has received. But that still doesn't go towards, well, what is the basis for their opinions? Simply put, plaintiff deserves to understand what authority are they relying on in forming these opinions. In re Allstate did not open this up enough that they can make blanket assertions without explaining how they came to these conclusions. And without that, these counter affidavits shouldn't be preventing these medical bills coming in to allow the jury to understand what was charged and what was reasonable and necessary. And so just for that reason, that they're not articulating the basis.
So Mr. Marquardt, deal with that particular issue.
Yes, sir. So the text
it doesn't sound like they're challenging the qualifications of the counter-affiance. They're challenging whether or not there's a sufficient basis within the affidavits to constitute a counter-affidavit. How do you address that issue? And
yes, sir.
Is that addressed in re Allstate?
Yes, sir. It's addressed by both the text of the statute and tangentially in re Allstate. So the text of the statute says that the counter affidavit must give reasonable notice of the basis on which the party serving intends at trial to controvert the claim. And the counter affidavit must be made by a person who is qualified by knowledge, skill, experience, training, education.
Okay, we're not going into that. You're to the particular question that we asked, or they asked. We're not dealing with qualifications. So deal with, is there a sufficient basis within the affidavit?
Yes, sir. And I understand that. I was getting to the point that their qualifications, their experience provide the basis. Plaintiff is arguing that we need to supplement by some.
So there's no methodology required within the affidavit, do you think, in re Allstate?
Correct, because
you could just say, is it your position? You can just say that I'm a chiropractor. Because I'm a chiropractor, I can say that these aren't reasonable and necessary without providing any of the best basis?
No, sir. No, that's not what the court held there. Under the re Allstate standard, a chiropractor would be able to provide a counter affidavit for medical expenses by another chiropractor. They wouldn't necessarily be able to provide a counter affidavit on medical expenses issued by a physician or a radiologist, for example. The court in re Allstate said that essentially the level needed to provide a counter affidavit does not meet the level to provide expert testimony. So we just have to provide a reasonable basis based on our doctor's experience and lengthy experience in the area treating people with similar injuries.
I may not be following your argument here. It seems like you're saying kind of an ipsa dixit that if I'm a chiropractor and I say it's not reasonable, it's not reasonable. That's what it sounds like you're saying, is because he's qualified to testify, he doesn't have to provide any methodology.
Right, because they're qualified, they have extensive experience in the area because they've treated thousands of patients with similar injuries. They can provide a basis that through their experience, the fees are unnecessary and unreasonable.
Okay. Response to that?
Well, just very briefly, Your Honor, even in re Allstate, the Texas Supreme Court made clear that in the absence of any other showing, a doctor's qualifications are not enough to controvert an affidavit. I understand that Dr. Clifford is a chiropractor. I understand that Dr. West may be an orthopedic, but they still have to describe what literature they reviewed, what processes they employed, what are they relying on in making these opinions. And if they're not providing that, they haven't provided a reasonable basis under the statute.
Okay. Yeah, I'm a little unclear on this argument here, but I'll go ahead and I guess based on the argument before me and the assertions made, I'm going to go ahead and grant the motions to strike. Was there a separate issue on the West, or are you going to make the same argument?
A similar issue, Your Honor. Just We deserve to see what facilities charges he was comparing or reviewing and what sort of literature he was relying on in making those opinions.
Anything different, Mr. Marquardt?
Again, Your Honor, this goes back to his experience and his knowledge in the field. He's basing both doctors are basing their opinions on how their own fees, their knowledge of the DFW marketplace, their experience with ordering and reviewing similar tests and procedures. So they are by far more than qualified and have given a reasonable basis for their decisions based off their qualifications and their experience in the marketplace.
Mr. Parr?
Your Honor, I agree with counsel, Mr. Byer here today.
Mr. Byer, I'm sorry, Mr. Byer.
Oh, pardon me. No, Judge, I think that's it. I think their qualifications alone, as the Texas Supreme Court has stated, isn't enough to form the basis of these opinions. He is, or a counsel for the defendant just referred to their own experience in running their practice. Well, they didn't even list what they charge for their own practice. We can't even compare towards what they do in their own clinics. They're again just making blanket assertions that these charges are unreasonable, the treatment wasn't necessary. I would have done X, Y, Z, but again, I haven't cited any sort of medical authority or compared it towards other named clinics that we could look at. They haven't listed an online database like the counter affiant did in Ray Allstate. And so just for these reasons, they haven't formed a basis.
I mean, I'm not sure.
I'm sorry, Your Honor, if I may briefly, this is Andrew Norman for defendant. To the extent that we want to, I guess to the extent that the plaintiff has no beef with the qualifications of the affiance, and it's more the text of the affidavit, our subsequent request in our responses to the motion to strikes was to provide maybe a supplement to these affiance. And so I think that, to the extent that, Your Honor, I know that you mentioned that you granted their motion to strike, but I guess in the alternative, we'd ask for the ability to amend these affidavits, to the court's, standing.
What I've been suggesting in all of these cases since in Ray Allstate is that, what I think would solve this would be just to agree to dueling affidavits, but I don't know if your firm allows that, Mr. Parr.
Your Honor, at this time, just simply based on, the arguments before us today and the lack of reasonable basis, we would prefer not to do dueling affidavits, but we always defer to the court and your decision here today.
I mean, I can't order you to do dueling affidavits, unfortunately. That's not within my power, I don't think. And so my main concern on these cases is that I feel that in Ray Allstate gives us a clear direction on where the Supreme Court is going on these. I don't like the way they're going, but I think it's fairly clear. And I hate to just create an appeal point within this case or any case that is, that could cause us to have to retry the case. And so dueling affidavits typically deals with that issue. And I'm concerned that cases that go up on the Supreme Court could make us have even more bad law here.
Yeah. We would agree to dueling affidavits, Your Honor, if the court suggests that that's probably the best way to move forward in this case. And Your Honor, is to go along with that as well, the parties are attempting to work out a settlement negotiations, and I don't think that should be lost on us here today. This is a Acccc bankruptcy case, and I think both myself and Mr. Norman wanted to get our associates a little practice here today. I'm
not familiar with the ACC. What is that?
The ACC, Your Honor, ACC Insurance Company is a company that went into receivership after being declared insolvent by the Travis County District Court last October. As a result, it became it fell down to what's known as the Texas Property Casualty Guarantee Insurance Association. It's a quasi kind of governmental agency that collects micro portions of premiums from every insurer in the state in order to fund when insurers go insolvent. And as Mr. Parr has excellently stated, we are working within the confines of the rules of the Texas Insurance Code, Chapter 462, which govern this case and relate to the issues of certain items that have to be of a specific discovery that have to be included in order for a settlement to be processed by the receivership estate.
Okay, so there's I've seen that dynamic in other insurance companies. That is there. So there's a good chance this may end up settling. It sounds like.
Yes, Your Honor. I would.
Mr. Norman, correct me if I'm wrong, but we've worked together to get all documents the state of Texas requires to defense counsel. And as of late, I believe the state of Texas is working on approving our bid in to collect some of the bankruptcy funds. And we're just, it's a slow process considering it, it's on a governmental level as well.
Mr. Norman, can you agree to dueling affidavits then?
Yes, Your Honor.
Okay. All right. So the parties have agreed to dueling affidavits. And Rhonda, make sure you include that in the notes. And we'll go from there. I think that's probably safer for everybody. And hopefully the case gets worked out. Okay.
Yes,
Thank
Your
you,
Honor.
Thank
you, Your Honor.
Honor,
Anything else today?
If you may, Honor, we have a trial setting for May 17th. And as counsel and I both stated, we are working within the confines of the state of Texas and their ability to pass information along to counsel in a timely manner. I assume that we will be filing a motion for continuance soon, and we'll be probably discussing that soon. I know that this case has been on your docket for entirely too long, but did want to let you know we'll most likely be filing one soon.
It's a 2020 case. I don't know that we're going to get to a whole lot of those this year, given our backlog. So I'm okay with moving it if you want to, but if either side has an issue with that, I'm not going to without it.
No, Mr. Parr accurately stated it. Unfortunately, with the way it works with the receivership estate and having to go it's not a highly staffed organization, and so and I want to correct, it's not actually a state of Texas. It's a quasi governmental type thing, but it's not a highly staffed organization. So I mean, it does work a little slower. And we were, like, as Mr. Parr stated, we would be looking for a continuance, Your Honor.
When would you guys like to reset it to? I don't want to reset it too far, but
no, I don't think anything real super far. I mean, Matt, would 6 months be fine? I mean,
that would be perfectly fine with me.
6 months from now or from the trial setting?
From the trial setting, Your Honor.
Any time in the fall, Your Honor, would be fine with plaintiffs.
How long would this case take to try?
Maybe 2 days, Your Honor. I apologize. I'm not ready to answer that question today, but I would assume 1 to 2 days.
I think that's accurate.
If you could try it in 1 day, I could set you on August 2nd. But I don't know if you can. Is this going to be with dueling affidavits? Usually, you can get them done in a day.
Right.
Or does that give you enough time, do you think?
Between Mr. Norman and I, we would both love to tell you that we're going to get this settled in 10 days, but we also know the structure in which we're dealing with, that we can't give you it's not amongst me and Mr. Norman about when we can actually enter into negotiations. We're both stalled right now. And not due to my client or his, defendant, due to other third parties that are beyond our control.
Do you have a sense, Mr. Norman, how long this will take?
No, I mean, like you said, I'd love to say, Your Honor, that we would have this authority in 2 weeks, and then Mr. Parr and I could have a reasonable conversation and get everything finished in another 10 days after that. But unfortunately, just with the staffing and they've had some turnover, I can't guarantee that we'd get anything, certainly in time for the May trial setting. But I think, if we looked at and I want to afford Mr. Parr the opportunity to get his affidavits in place as well in case settlement discussions don't work. And so I think if we looked at maybe somewhere in October, November, I think that would be most comfortable for everybody involved.
I agree with that, Your Honor.
All right, how about October 4th?
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Ronnie, go ahead and reset it to October 4th. You guys have a great rest of the day, and